Good afternoon. My name is Max Stainton. I am a graduate student studying philosophy and law, and today we're going to do some legal philosophy. If that sounds daunting, don't worry. My thesis is actually really simple. If you're a non-philosopher, you're actually at an advantage here. So here's the thesis, okay? Law and morality are inextricably linked. All positively made human laws are in some way dependent upon morality. That's it. That's the idea. Therefore, to properly interpret legal doctrines, judges must look to morality to properly understand what they're deciding. So this idea is generally called natural law. It is the dominant view throughout history. Every major philosopher you've heard of believes in it. Cicero, Plato, Aristotle, Augustine, Aquinas, George Washington, Thomas Jefferson, James Madison, James Wilson, everybody who wrote our Constitution. They're all natural law theorists. That means that they think that there's this real thing called morality out in the world, and it governs how we should act. Don't kill, don't lie, don't steal, those sorts of things. And these are requirements regardless of whether we're in a state or not, regardless of whether the state is telling us to do those things or not do those things. This is contrasted to the modern view, which is called positivism, meaning the only thing that governs is what is positively written down. Okay? They're agnostic about whether law and morality go together. Elena Kagan sums this up really well during her confirmation hearing. She's asked her view on natural rights, and she says, to be honest, Senator, I don't have any view about natural rights outside of the Constitution. That's positivism. So, why might we believe in natural law? Well, let's start with an easier question. Why are you here today? Not in some big metaphysical, esoteric sense, but practically, like, why did you come to this event today? Maybe you're here to support a friend who's presenting. Maybe you care a lot about learning a new language. Or maybe you're a professor and you're paid to be here. Whatever the particular reason is, the general reason why you're here is that you think this is the best way to spend your time. If you didn't, you'd be somewhere else doing something else. This is called prudence, or rationality for philosophers. If you're in the business world, you might call it marginal return. Everybody has it. We try to maximize our utility. We try to do the best thing possible for us. How do we achieve that? How do we have the good life? Well, if you believe in moral realism, it's really easy. You just do what's morally right. Augustine defines morality as the recipe for a happy life. If you help a stranger, if you call your mom on her birthday, if you give some money and time to a cause that you care about, if you're willing to love a neighbor like yourself, you're going to have the best life possible. If you don't, if you give in to your vices, they're going to bind and constrict you, and your life's going to be worse off. So that's the whole argument. We got two premises. One is prudence, that we all act to maximize our utility, to improve human flourishing. And the second is that morality is a real thing, that the best way to maximize your life is to do the right thing. And that can lead us to our conclusion that morality is going to constrain all of our actions and all of our creations, including law, also including sports, also including fashion. All of these things have a moral goal. That's why they're created. And so to interpret them correctly, we need to do some moral reasoning. Okay, that's the theory, that's the whole thing. Does it happen in practice? Yes, we see this in moral laws where they are explicitly referring to this concept. We see them in immoral laws where judges are trying to counteract that. And we see it in amoral laws where you wouldn't really expect this to show up, like traffic law. So let's start with moral laws. Natural rights, that's a huge concept in American law. And we see it most explicitly stated in the 9th Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Okay, that's great, but I'm a judge. How do I know which other rights to protect? Well, I have to do moral reasoning. I have to know which are natural rights that would be protected. Similarly, the 14th Amendment guarantees equal protection of the law. Okay, great, we've got this moral provision in there, equality. That's a good value that we all want to uphold. But if you just look at the text, equal protection, you don't know if you should achieve equality by raising the lowly up or by tearing down the powerful. But time and again, we see courts raising up the lowly by ending segregation, by giving us rights to privacy, by guaranteeing stuff like the right to abortion. The point here is not that you agree with the moral outcome of these cases. If you like gay marriage, you probably don't like robust gun laws like we see in the Heller case. The point is that judges are doing moral reasoning because it's required to understand what's going on in the laws. We also see this with immoral laws, chief example in American history being slavery, of course. Now, do judges sit there with a decision and say, I'm going to overturn all the rules that protect slavery. No, because they have some deference in their role. So judges are doing moral reasoning, so are legislatures, the voice of the people. And judges generally refer to the people on what is the morally right thing to do. But they nip around the edges when they can. So if American forces capture a French ship engaged in the slave trade, judges say, unconstitutional, can't do it. Why? Because it's repugnant to the great principles of Christian duty, the dictates of natural religion, the obligations of good faith and morality, and the eternal maxims of social justice. It's wrong. That's why it's prohibited, natural law. We also see this, again, surprisingly, in the amoral law section, stuff like traffic laws. So People versus Marsh, this is a California case where two cars pull up to an intersection. They both stop at a red light, and one car, light turns green. A car zooms in front of the other one, turns left, keeps going before the other car can even get off the line. If you live in Philadelphia, this has happened to you. It's very frustrating, very unsafe, not a fun time. The text of the statute about what you're supposed to do at a stoplight says that you aren't allowed to turn left when traffic is approaching. That's the language in there. But the other car isn't approaching. It's stopped at the line. And if you look back at the legislative history, the California legislature actually put in language that said is stopping or has stopped. And they took it out. So if you're a judge and you're just looking at the text, you're just looking at the law, and all you have is this is approaching language, and you know that they could have put in or has approached, and they chose not to, what should you think? You should think this is legal. You should think that it's perfectly legal at this, when the light turns green to zoom across and cut the person off. Is that what courts say? No, of course not. This seems like such a patently bad idea that it would be insulting to ascribe it to the legislature, and we will not. Judges can't help but to engage in moral reasoning, either when there's an immoral law, a moral law, or an amoral law. It's part of the fiber of being a judge. It's part of what law is. It's part of what all of our systems are. They're designed to maximize human flourishing. All laws are made with moral goals because governments seek the improvement of their nations. This is how it has to be. So for judges to correctly interpret human-made laws, they must engage in moral reasoning to determine their legal content. Thank you.